Right, I'm going to go ahead and get started since this is being recorded live. As you all decide to join in, you can come in on the conversation. I am live via Facebook, I'm live via Instagram, but I also am recording a video. So I want to just go ahead and get started to get this going. Hello, I'm going to get started. Thanks for joining, but I'm going to go ahead and get started because like I just said, I am live on Facebook on one device, I'm live on Instagram on another device, and I am recording this information for YouTube. So I'm going to go ahead and get started. This live is about the CTA, the Corporate Transparency Act, and I have, received some phone calls and of course dealing with clients, having questions about what this court ruling means for them if they have not filed already, and what does this court ruling mean for them if they did file. So in addition to talking to my clients or those who called me, I decided to go live and record a video for individuals to just go back and play and have this information for themselves. And when I say individuals, I'm speaking of those who may have a business entity, whether it is a LLC, a corporation, anything that you actually register under the Secretary of State. This is a very important situation that's going on. I don't think that a lot of us even grasp the severity of the situation, but I think that we should get some type of hunch if there's constantly court cases about this. This is not the first court case. There have been other court cases, some that are on appeal, where plaintiffs, those who bring the suit to the court, are pushing back on this government regulation. And there's a serious reason why. So this is very important for us to understand what's going on, especially since there is monetary implications to this. So we will be penalized monetarily if we don't understand it, but also there's jail time connected to it as well. People can actually be fined and or imprisoned. So this is very serious. So I just wanted to come on here really quickly to talk about the new ruling that happened in a district court, where the court found that this needed to be stopped for right now. That's called an injunctive relief. So I'm trying not to be too legalese. I'm trying to really think about my words here because I want to speak to you with layperson terms. I don't want to get too legalese. I want it to be digestible and understandable. So in this recent court case on December 3rd, the judge did issue what's called an injunctive release, which means we're going to put a hold on all of this. There's a deadline coming up, January 1st, 2025, where any individual that has the business entity formed through the Secretary of State in the U.S. has to file a beneficial ownership information report. I don't want to get all into that. I do have several videos on what the CTA is. I have videos on what needs to be reported, how it needs to be reported, when it needs to be reported. I don't want to get into that here. But on my YouTube channel, Seek Ellavation, ELLAVATION, you can go look at those videos. But here, I want to talk about the judge said, let's put a stop to this. And the reason why the judge did that is because the plaintiffs, there were 6 plaintiffs, one individual and 5 entities that brought this to the court. And they said, listen, we feel like this is unconstitutional for us to be forced to do this. Again, this is not new that these plaintiffs have done this. Other individuals have done the same exact thing. But where this is different from other court cases is one of the plaintiffs is a company or entity called the National Federation of Independent Business, the NFIB. And the NFIB has 3,000, I believe, other entities that it services. So because it has other entities, other businesses that it services in different states, however the judge was going to rule in this court case was going to affect everyone nationally. Whereas previous court cases, when the plaintiff the business or the individual brought this in front of the judge, that ruling only affected the state in which they were in. But this ruling is national. So this injunctive relief, again, meaning this halt, this stay is what we call it legally, that was put against the federal government, is going to affect all of us nationally. And what the judge looked at is the Constitution. They looked at the 10th Amendment. Now, the plaintiffs brought this to the court, and they said that it violates the First Amendment, the Fourth Amendment, the Ninth Amendment, the 10th Amendment, but the court said we don't have to look at all the other ones. We're going to look at the 10th Amendment, which says federal has its power, states have its power. That's federalism. There's certain things that the federal level governs, and there's certain things that the state level should be able to govern on their own. And in this case, when the judge assessed all the facts, the judge looked at it and said, we feel as though the federal government is overstepping its boundaries by forcing each state to comply with this federal law. So that's where the judge said, let's put a stop to this until we can iron it out. So what I want to really point out is in this court case, although we have an injunctive release, meaning you do not, if you have not filed yet, and the deadline is January 1st, 2025, you do not have to file. You do not. If you already filed, you already did it. But if you did not file, you don't have to file yet until they continue to iron this out. So the question I get is, if we don't have to file, does this mean we don't have to file for good? No, it doesn't. This case right now just says everything is being put on hold until we really iron out the constitutionality of this federal law. And honestly, as I read the case, 42 pages, that's what an ownership attorney does. I go in, I make sure I stay on top of cases that deal with business entities, intellectual property, all that good stuff. So as I read this case, for me, in my analysis, I'm listening to what the judge is saying. I'm listening to how the judge is using certain things to make its ruling. And it sounds like to me, if other courts, because trust me, FinCEN, they're going to appeal. They're going to appeal this. But if other judges read what this judge has said, this is called precedent. They look at other court cases as well. I think it's going to be a tough one. I do think it's a tough one to overcome that constitutionality barrier. And why do I say that? Because there are certain powers that's invested, right, within Congress. And the judge in this particular court case really drilled down on that and said, okay, you have certain powers that's invested in you in order for you to do whatever. You have the powers for interstate commerce, and they also have a power called necessary and proper clause. Interstate commerce just means you have the power to overlook businesses moving goods and services throughout the states. You also have the power that if it's not written in a constitution, you also have the power through the necessary and proper clause to create certain legislations that are aligned with the powers you do have vested, if that makes sense. As the judge looked at everything, FinCEN, the BOI, it does not align with interstate commerce. Why doesn't it align with interstate commerce, you might ask? Because you're looking at businesses. Why doesn't it? Because if you read the regulations or the legislations of the BOI, it says, of CTA, it says, if you formed a business entity in the U.S., or if you're a foreign entity and you're doing business in the U.S., and you have filed to do such, then you have to report. It doesn't say you're necessarily doing business. It just says if you filed or formed an entity. Some of us form entities as holding companies. Doesn't necessarily do business. Some form entities to hold real estate. Doesn't necessarily mean you're doing business. So what the judge looked at is it doesn't fit into interstate commerce because you're assuming that everyone who forms an entity is actually active or doing activity in interstate commerce, and that's not the case. So that means it's not in your jurisdiction. You don't have hooks in every business. And then secondly, they already looked at the necessary and proper clause. Remember, I told you that clause is just there to say, if the powers that you need are not necessarily written in a constitution, you can do what's necessary and proper to align with those particular powers. But what the judge looked at is, again, if there's something not written, whatever you need to write, it still has to align with whatever powers that you actually have. And in this case, again, the judge said you don't have powers as of right now. What we see, you don't have powers to regulate every business. And to give you a number exact, I think they said it was like 3 million businesses, 3.6 million businesses. And they said every business is not actually active. So you cannot blanketly put this legislation in place to regulate them. And also what the judge said is we look at this as you policing them on what possibly can happen, not policing them on what actually happened. Because FinCEN states that this whole Corporate Transparency Act is really to help with money laundering, anti-terrorism. They're stating that you're assuming that every business that you're trying to police may be involved in those activities, and that's not the case. And an assumption is not strong enough to roll out this type of legislation, let alone they just don't have the vested power under interstate commerce. And the NFIB, the big plaintiff that helped all of us in this, actually is serving 300,000 members, 300,000 businesses. And because they are serving 300,000 businesses, it's a national, when the judge made its ruling, it applied nationally. And because it applied nationally, it helped all of us in every state. Are there any questions for those who may have businesses that are confused about this particular legislation or confused about the ruling? I guess the main thing you want to hear, though, if you have a business, do you have to report? No, you don't. You don't have to report by January 2025, that deadline. You don't have to report, and you will not be fined because there is an injunctive relief that was put on FinCEN, dealing with the CTA. If there are any questions, let me know. But I try to give it in a very concise, without covering all the legalese, try to give it in a very concise manner and really just get right to the point, which is people just want to know, do I have to report? But I will say this, as they appeal this, and I'm sure they will, when they appeal it, if they win on appeal and you didn't file by the deadline, it will not be retroactive. You won't go back and they won't go back and say, well, we won now and we had this particular deadline, you should have filed. That's not, the court ruling says no. The stay is put on here. There will be no type of irreparable harm that could be done to those who didn't file. And then if they do win, then at that time, they can then state when the new deadline is. And they can obviously state what the penalties are if you do not file at that particular time. But for right now, you do not have to file. That injunctive relief applies to all business entities that FinCEN listed nationwide. Are there any questions? Hey, Neil. I hope all is well. All right, so if there are no questions, hopefully that helps you. Again, I'm here to try to help us. We a lot of times get lost in the sauce. We do not know what's going on. And I personally am happy that this court ruling did come down because I don't think a lot of people would have realized they've been paying $500 a day. As of January 1, 2025, if you did not report, your fine would have started, and it would have been $500 per day that you do not comply. Not to mention, if there's errors and you don't fix those errors, there's going to be penalties for that. If you do not report correctly, there was going to be penalties for that. Filling out the beneficial ownership information report is not hard at all, but knowing what to fill out could be tricky. And that's where a lot of people would have gotten caught up. If you are a solopreneur, it may have been a little easier, right? Because you kind of know it's just you and you can fill that out. But once ownership goes 2 or more people, then that's what would have become more and more trickier. Not to mention if you have board of directors, it would become very, very tricky. And I have consulted so many individuals who didn't even realize that certain partners or individuals in their companies that hold senior positions, the CEO or whatever else, you are a beneficial owner. If an individual owned 25% or more in a company, they're a beneficial owner. So those were 2 ways that people were beneficial owners, and other companies that were tied to each other was owning. So there was information that was needed to be reported on those companies and those individuals, very personal information and business information. Again, right now is adjunctive relief, but if they do win on appeal, we're still back at square one. So it will be very, very, very important for you to stay in the loop on this, especially if you own a company or you know someone who have registered a company in the U.S. All right, so that is all that I wanted to cover, just to make sure that we understand what's going on. And right now you can pause if you did not file. And if you did file, well, your information is already out there. And maybe if they find it unconstitutional, they will force them to get rid of that information. But we know how the government works. How do you know if they got rid of it? But yep, that is all. So you all have a good night. I just wanted to make sure I bring you that information. Good night.